Whether you're 17 or 77, this court will make sure that you're homeless when you get out and make sure that you have plenty of fines to pay and also make sure specifically that you're homeless. Um, they'll keep you in there long enough till your home disappears or knowingly put you back out on the street if you live in a tent. They do not give a shit. The 13th Judicial District is garbage. However, there again is one person that is doing the right thing in all this bullshit, and he's that guy in the bottom right there.
Warrant to show cause alleging probation violation, including failure to obey the law resulting in conviction. On some City of El Dorado cases. Further violations that are alleged in this case would include failing to refrain from the use of alcohol or illegal drugs and failing to pay as directed. What announcement is made at this time regarding these allegations, Mr. Patterson?
Your Honor, after a review of the file and also email communication with Mr. Sweeney, I believe there is an agreement in this case that the court does not have subject matter jurisdiction, that at this time the case should be, the warrant should be withdrawn, the case should be closed, and costs, fees, and fines should go to collections.
Of this court, Mr. Patterson.
Your Honor, the basis is that on December 9, that was the end of the 1 year. December 9, 2023 was the end of the first year of probation, that the warrant to show cause was not filed at that time until January 3rd, 2024. That because of that, the court lost subject matter jurisdiction, that January 3rd, 2024 was outside of the 1 year and also outside of the 30-day additional time that's allowed. Because the court lost jurisdiction at that time, there cannot be a reinstitution of jurisdiction. Once lost, it's gone, and therefore the case should be terminated.
Right. Perhaps the dates that I've noted here are not correct. You're stating that the original probation period expired December 9 of 2023?
Yes, Your Honor. The original sentencing was November 9, 2022. The court did place him on a 1 year reporting probation. Therefore, the 1 year ended December 9, 2023, or I'm sorry, November 9, 2023. I apologize. And then with the 30-day additional time period for filing, it went to December 9, 2023. And of course, at December 10, the court lost jurisdiction, and that warrant at that time was not filed till January 3rd, 2024.
All right, I'm going to turn to Ms. Teal, the representative here from Court Services. Do you agree with these dates regarding the case status in this matter?
Your Honor, I've reviewed everything that Mr. Patterson's talking about, and it was the time that in October of 2023 to December of 2023, the court system was breached, and there was a lot of filing issues, and I think everything he is stating is accurate, and there was just delays in getting things timely file stamped and in the system during that time period.
All right, very well. Mr. Sweeney, on behalf of the state of Kansas, are you in agreement with the announcement that was made by Mr. Patterson and what he says the status of this case is?
I am, Your Honor. I had initially looked into the fact that there appeared to be subsequent show cause hearings after that initial date period. But Mr. Patterson was able to provide me some case law that appeared to show that that jurisdictional issue can't be waived by the defendant. That was kind of one thing I just wanted to make sure of. He did provide me some case law to that end. So I'm satisfied. I wish I could say that there is some sort of exception for hackers, but there's nothing I could find that I think would get us back right.
All right. The court certainly understands Ms. Teal's statement regarding the disruption regarding filing and the deadlines that was created by the cyber attack on the court system's electronic filing system. It very well could have led to delays which prevented the filing of a timely request for revocation of probation in this case. It does appear from the dates provided that the ultimate filing in this case was outside the allowable 30-day window past expiration date for the probation, which means the court does lack jurisdiction to proceed with revocation at this point. Mr. Derringer. Darren?
Yes, I'm here.
Okay. Do you understand what's going on here?
Yes.
Okay, let me ask you, do you have other cases pending right now besides this one?
The only cases that I have for state is the 2 new charges that I had, which was Walmart theft and giving that 14-year-old a vape. And that's all I know of.
All right, I'm just curious as to you have any holds on you other than this?
Not that I know of.
Okay, obviously the jail will let you know.
Yeah.
All right, the court does find that it has a lack of jurisdiction at this time to proceed further on the warrant to show cause alleging probation violation. It does appear that the case is effectively terminated at this time. However, anything that has not been paid at this point will be referred, if it hasn't been already, to a civil collection agency for further handling. In other words, Mr. Derringer, if you owe money in this case, you still owe it. And you may be pursued in the future by a collection agency. However, you don't have any other responsibility to report or otherwise answer in this criminal case. So you're to be released on any hold that's connected with this current warrant to show cause. Anything related to case number 2022 CR 329 is dissolved, and you're free to go in relation to this case. Mr. Derringer, as I was alluding to earlier, if you have any other holds on you, I'm not releasing you from those. Just the case number of 22 CR 329.
Okay.
I hope that there is a representative at the jail handy who's hearing this matter currently before the court and can take appropriate action.
Yes, sir.
Okay. Mr. Patterson, is there anything else we need to address here?
No, Your Honor.
Obviously, no further waves will be connected with this round. Mr. Sweeney, is there anything further from the state's perspective that we need to address?
No, Your Honor.
Ms. Teal, anything further at this time?
No, sir.
No, thank you for your appearance here today. Last but not least, Mr. Derringer, you have any questions about what we've done here today?
No, sir.
Okay, you're going to be released on this case. Do you have somewhere to go?
Yes, I do. I have I honestly live in a tent at the Incomni Inn, and I have good friends there that are actually good friends that'll help me get a job and help me get a place.
All right, I hope so. All right, good luck to you, Mr. Derringer. I hope you're okay when you get out.
I will.
All
Thank
right. If there's nothing further then, the Derringer matter will be in recess at this time. Mr. Patterson, are you covering Mr. Watts in his other case today?
I have not been contacted by anybody, Your Honor.
Okay, thank you. Then I can go ahead and release you from the meeting, Mr. Patterson.
Very good. Have a good weekend. Thank you.
You too, sir. All right, Mr. Sweeney, let me ask you, are you aware of who is, from the defense counsel side, is handling Mr. Polson today? It does look like that Mr. Favre was actually appointed.
It looks like the email communication from Miss Norris to the defense counsel in this case looks like it's all been directed at Mr. Favre. So that was my understanding of who would be here today, but it's not my case. But I do have down that there has been some communication on our side.
Okay. The case I'm referring to, obviously, is State of Kansas versus Andrew James Polson, case number 2023 CR 481. There's an individual at the detention facility Zoom location. Are you Andrew Polson?
Yes, sir.
Okay. Have you talked to Joseph Favre about your case?
Yes, sir.
Okay, I'm not sure where Mr. Favre is.
Oh.
All right, I'm going to recess briefly. I'm going to have my assistant try to contact Mr. Favre, and we'll leave this Zoom meeting open until further proceedings are conducted. Court is in recess at this time.
George Allen Lux,
How old are you right now?
77.
Okay. What's the highest level of formal education that you've attained?
Oh, I graduated college with an agricultural degree from Fort Hays State in 1973.
Now, do you believe you're going to have difficulty understanding any of the legal concepts that we're going to be discussing in court here this morning?
Yes, sir. I don't understand most of them.
Okay, well, if there's, again, I want to make sure that you are understanding what we're doing here. So let me know if you're having trouble along the way, okay?
Yes, sir.
All right. Mr. Likes, have you ever been adjudged to be mentally ill?
No, sir.
Are you currently under the influence of alcohol or any drug?
No, sir.
Mr. Likes, are you currently under the influence of any prescription medication?
I take quite an assortment of pills each day.
Right. Do any of these pills impair your ability to understand things?
I don't believe so.
All right. So you think this morning, Mr. Likes, that your mind is clear and that you have a full understanding of what's going on here so far?
Yes, sir.
All right. Do you understand the nature of the charge against you in count one of the information, driving under the influence, third offense in 10 years?
Yes, sir.
All right. And do understand the nature of the charge of circumvention of an ignition interlock device as charged in count 3?
To some degree, I do. Yeah. Yes, sir.
Well, it's relatively straightforward, Mr. Likes. Under certain circumstances, Kansas law requires certain individuals to have an ignition interlock device in their vehicle to check for possible alcohol usage. You appear to have been an individual that had that requirement. The state's alleging that you were required to have an ignition interlock device in your vehicle and you drove a vehicle without having one. You understand that?
I guess so. Yes, sir.
Okay. Like you understand that when you enter a plea of no contest, you are not necessarily admitting that you did these acts, but you're also not contesting that you be convicted just the same. You understand that?
Yes, sir.
You also understand that when you enter pleas of no contest, you give up any legal defenses that you might have had to those charges. Mr. Weiss?
Yes, sir.
All right. You further understand that in a trial, the state must present evidence against you in open court, that any witnesses have to testify in open court in your presence, that you have the right to cross-examine witnesses and to present evidence at your trial on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that you could testify under oath at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. You understand that, Mr. Likes?
Yes, sir.
You understand that when you enter pleas of no contest, you give up these valuable trial rights that the court has described.
Yes, sir.
You also understand that you have a right to a trial by jury and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes, sir.
You understand that when you enter a plea of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, sir.
You understand, Mr. Likes, that you have a right to appeal a guilty verdict if you have a trial.
Yes, sir.
You further understand that you may appeal your sentence after entering a plea of no contest, but generally you may not appeal your judgment of conviction after you enter such a plea.
Yes, sir.
Now, are you aware of the penalties that could be imposed as a result of this guilty plea that you are attempting to make?
No, sir.
All right, well, we're going to go over those. I would have thought that someone would have discussed that with you already, but the DUI charge, as it's currently charged against you in this case, Mr. Likes, is a level 6 felony under Kansas law. On level 6 of the Kansas Sentencing Guidelines Act, non-drug offenses, in the most favorable criminal history category of I, you could receive as little as a 17-month sentence. However, in the worst criminal history category of A, you could receive up to a 46-month sentence. So the sentencing range is 17 to 46 months in prison, depending on your criminal history. Mr. Likes, as you sit today, we do not know with certainty what your criminal history is. You better than anyone else here should really know what your own criminal record looks like. But that will be researched by the Court Services Department, and based on the outcome of that research as of the date of sentencing, that will determine where you fall along this level 6 line, and then you'll be sentenced accordingly. Do you understand that?
Yes, sir.
You also understand, Mr. Likes, that if you have a felony on your record already, you would be presumptive prison under Kansas law.
Yes, sir.
All right. You also understand that you could receive up to a $300,000 fine for this offense.
Yes, I guess I do.
All right.
I don't know where I'd get that kind of money, but
I'll take that into account at time of sentencing, Mr. Lutz.
thank you.
All right. You're also attempting to plead no contest to circumvention of an ignition interlock device. That's a Class A non-person misdemeanor, punishable by up to a year in the county jail and up to a $2,500 fine, or both. Do you understand that?
Yes, sir.
Okay. In addition to any fines that could be imposed, Mr. Leitch, do you understand that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes, sir.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes, sir.
You also understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances. Do you understand that?
Yes, sir.
You also understand that the Kansas Sentencing Guidelines Act has special sentencing rules. Do you understand that if there are any special rules that apply to you in your case, it could affect your eligibility for probation or otherwise affect your sentence? You understand that?
I didn't get the front of that, Judge.
I wanted to talk to you about the fact that the Kansas Sentencing Guidelines Act has special rules within it. And that if any of the special rules apply to you for any reason, it could affect your eligibility for probation or otherwise affect your sentence.
Yes, sir.
Now, have you had an ample opportunity to discuss legal matters like that with your attorney, Gary House, before proceeding here today?
Would I like to discuss that with him?
Do you think you've had enough opportunity already?
I've not had much discussion with him, but I don't know that I'll absorb any more information from him than I have already.
Okay, I'm just offering you the opportunity. Do you want to talk to him right now, Mr. Likes, privately?
No, sir.
Okay, well, we'll go forward then. Now, are you satisfied with the services and advice given to you by Mr. House?
Yes, sir.
Okay. Now, these no contest pleas that you're attempting to make, had they been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, sir.
Okay. Mr. Likes, do you understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made? The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, sir.
So let me ask you, how do you formally plead to the charge in count 1 in this case, a charge of driving under the influence, third offense in 10 years, a level 6 non-person felony.
No contest, Your Honor.
And to count 3, circumvention of an ignition interlock device, a class A misdemeanor.
No contest, Your Honor.
I'll ask the state's attorney for a concise factual basis as to each charge.
Your Honor, on October 30th, Sergeant Cordell was sent messages with photos of Mr. Likes driving in the Climax area. He drove down towards Climax and found the defendant driving the red and white older model Ford pickup with the stock trailer. And he knew that Mr. Likes had a suspended driver's license and an ignition interlock restriction. So he effectuated a traffic stop on Mr. Likes in the vehicle. As he went to turn around to effectuate the traffic stop, the vehicle weaved across the solid line into the southbound traffic lane. The vehicle was stopped. He traveled 1.5 miles before turning on to 230th Street North and parking. The investigation discovered that he had been, he reeked of alcohol and that he had an open container with him. He was suspended and restricted, and there was no tag on the vehicle. He was arrested and had issues with being able to do things. He had also urinated in his pants and had many signs of being under the influence and of alcohol. He then had blood draws done and was under the influence. He has 2 prior DUI.
Okay, let's back up a minute. What was the testing result in this case?
Judge, I don't know if it's been received back yet, because this was fairly recent in October. But he was so drunk, he had peed his pants, couldn't stand, falling over, had a lot of trouble. So.
Okay, he wasn't charged in the alternative here, from what I can see. He was just charged with having a blood alcohol concentration of 0.08 or more.
Judge, will amend that to say that it was to a degree that rendered him incapable to drive.
Any objection to that, Mr. House?
No, Your Honor.
All right, very well.
There was many difficulties with him. He has prior convictions. We have the certified conviction from the city of Colwich Municipal Court. We have the certified journal entry from the plea and sentencing in Greenwood County, case number 2020 TR50. The Colwich case number is 2026. We also have the conviction from the Eureka Municipal Court. So all of those convictions are prior DUIs on Mr. Likes' record, making this a third or subsequent DUI. And he was, in his certified driving record, does show that he's restricted to interlock device and cannot operate a vehicle without one.
All right. And this vehicle obviously did not have a proper ignition interlock device installed within it when he was driving.
No.
All right. All right, Mr. Likes, do you now freely, knowingly, and voluntarily enter pleas of no contest and accept conviction for driving under the influence, third offense in a 10-year period in count 1, and circumvention of an ignition interlock device, a class A misdemeanor in count 3?
Yes, sir.
All right, Ms. Gillett, do you know of any legal reason why the court should not accept this defendant's pleas?
No, Your Honor.
Mr. House, are you aware of any such legal reason?
No, Your Honor, and I would like to say for the record that Ms. Gillett and I have talked extensively about the cases in Elk County and Greenwood County and prior driving record of Mr. Likes. we believe that his criminal history will show that about the only thing on his criminal history will be traffic offenses and DUIs. A part of our plea agreement is a joint recommendation to the court that Mr. Like get into a sober living house now, and he has agreed to that. And then if the court service officer or the intensive supervision officer, depending on where he's placed on probation, if he's placed on probation, finds that he needs an inpatient treatment program, he will do that. He's been in jail in excess of 30 days at this time. I've had discussions with Philip Webb, who runs the sober living house in El Dorado, and we would hope that he could get an OR bond to go directly to the sober living house when a vacancy is available, and there should be one coming up shortly.
All right, I'll deal with the issue of bond in a little bit. Mr. Likes, do you know of a legal reason or any other good reason why the court shouldn't accept your pleas here this morning?
No, sir.
All right. Court will accept the no contest pleas made by George Allen Likes and finds that those pleas are made voluntarily. Mr. Likes has an understanding of the nature of his charges and the consequences of his pleas, and a factual basis for each charge does exist. The court accepts the no contest pleas and finds George Allen Likes guilty and convicted of driving under the influence. A level 6 non-person felony is charged in count 1, and also circumvention of an ignition interlock device in count 3. All other charges of the charging document in that case are dismissed pursuant to plea agreement, as well as the entirety of case number 24 TR 655 of Greenwood County. Court will order a pre-sentence investigation to accurately determine Mr. Likes' criminal history, and the court will set an appropriate date for sentencing. We're looking at Thursday, February 20. Mr. House, any scheduling conflicts on your calendar I need to be made aware of?
No, Your Honor.
All right. I think we've done really well bright and early at 9 o'clock this morning, so we're going to go ahead and stick with that time. 9 o'clock a.m. Thursday, February 20 for the Likes sentencing. Obviously, Mr. Likes must be fully engaged and present at that time for sentencing in his case. February 20, 9 o'clock a.m. Let's look at Mr. Likes' bond status in this particular matter. Dealing only with bond status in 194 at this juncture. What's the status of his no bond hold status in Elk County?
It was modified, I think, Your Honor.
Okay.
There's a motion regarding his bond on file as to why it was changed here to no bond, Your Honor. Mr. Likes on that motion had gotten the first case in Elk County. And again, this is the history that's on file that was before Judge Webster, before it transferred up to you on the waiver of prelim. He has 4 cases. He has a Butler, well, 5 total. He has a Butler County case, May 27th, 2024, for driving while suspended. They did not charge him with the no interlock or anything else at that time. They simply only charged him with the driving while suspended. On July 8th, 2024, in Elk County, he had driving while suspended, no insurance, no seatbelt, failure to turn, and window tint. We have disposed of the 2 Elk County cases, and he's currently on probation there. And then while on bond for Butler and Elk, Mr. Likes had a driving while suspended and transporting open container and no tag. It was a wrecked vehicle, and we couldn't tell if he drank post the accident. So we did not charge him with DUI. This case occurred October 30th. Driving under the influence, driving while suspended, no ignition, interlock, and transporting open container, no tag. When he was stopped in this case and arrested, I asked for scram, and he was put on scram here. The day of October 30th, he failed to appear in Elk for a hearing, was given no bond holds. He was arrested by Greenwood on the 30th and served with the warrant from Elk on the 31st. It had the no bond hold and held him. We released him on the cases with scram. And then on November 9th, and he was released November, I believe, 8th or 9th. I think it was the 8th. On the 9th, while on scram, he had been pulled over, driving while suspended, no ignition, interlock, no tag, transporting open container, and no vehicle liability insurance. We got a email report from the scram monitor for the exact time he started drinking and the time that he was stopped, and the blood alcohol came back down in the jail. He was continuing to drive and drink while driving. So he has been in custody since, because we already tried scram. It's one of the reasons Mr. House and I have talked at length about getting him a drug and alcohol evaluation, which is in the process. I don't know where they're at. I believe Road to Recovery is working on it. And that we wanted to have him go directly to a sober living house and have someone with a valid license pick him up and transport him straight there. That's the crux of what the history has been and why he ended up back in jail.
All right, Mr. House, regarding the statements that you had made earlier about requesting a modification of his bond status at this time, what would you add?
Well, Your Honor, I do think the drug and alcohol evaluation has been done by Road to Recovery, and there should be one. I haven't been back to my office for a couple of days, but I think they intended to file one this week. So, and I think that it was going to be an and/or recommendation of sober living house directly from the jail or an inpatient treatment program.
All right. Is there a bed in either one of these types of facilities available for Mr. Likes at this time?
Your Honor, I'll have to check this morning. I checked with Mr. Webb last week, and they were full at the time. They said they would admit him, and Mr. Webb said that he had some people who were moving out, and so I'll try to confirm that with him today.
All right, Mr. Likes, you got your hand up?
Mr. House says that sober living house in El Dorado is I have no driver's license and no vehicle, obviously, and that in-house counseling might serve me better than trying to get around El Dorado to meet all these requirements. I don't know where it is, but maybe something that I might like to look at, the in-house counseling.
They will just pursue
About inpatient treatment center. All right.
Yeah. Yes, Your Honor.
All right, I'm backing up here on this case. So if his no bond holds were removed in Elk County, how was a no bond hold put on him in this case?
Because he was arrested on that newer case that we we did dismissal on pursuant to the plea agreement. This case ended up having its bond revoked because he got arrested in the new case, transporting alcohol, driving, no interlock, no tag. He went out and got a different vehicle and was,
All right, so for bond condition violation,
yes.
and what legal authority is there to do an outright no bond hold because he violated a bond condition? It would seem logical that the court would have the authority of doing it, but there's a statutory scheme here, and I'm just wanting to know what statute was relied upon to put Mr. Likes in jail on a no bond hold.
I believe it was bond condition and public safety, Your Honor.
Well, whatever. All right. Right. The court is trusting at this juncture that Mr. Likes has eligibility for release in regards to all other cases that he's currently got pending, which apparently might be narrowed down at this point to something in Butler that he's got.
His Butler County case he's on bond for is just driving while suspended.
Okay.
The Out County case, he's been placed on probation.
Okay.
And this case is pending sentencing and has the no bond hold. We're asking to transfer him directly to a sober living or a inpatient treatment when it's available. And we would circulate a OR if you enter the order today, that as soon as it's available, he can be OR directly to sober living or treatment. I know Philip Webb was working on getting him a bed. And if not, Peggy Collins at Road to Recovery is working on a treatment facility for Mr. Likes. Mr. Likes had a 2020 case he got off of in, I think, 22, maybe 23 DUI, and we had him in treatment then.
I don't think Mr. Florio has been released as a bondsman in this case. What the court's inclined to do at this point is to reinstate Mr. Likes under his appearance bond of $17,500 through Florio and his bail bonding company, since he has not been released as surety. But Mr. House, what I really want to see is Mr. Likes, who cannot drive himself, get into one of these facilities right away. Is there anything that you can do to facilitate transport to one of these two facilities?
Your Honor, would law enforcement be able to do that?
I don't know if the sheriff has the people today to do it.
I was wondering if either one of these, either an inpatient facility or the sober living house, has their own transport mechanism that they can take him there. Because Mr. Likes, you can't drive.
I understand, Your Honor.
Under any circumstances.
Right.
And you can't be drinking under any circumstances. So as a condition of reinstatement of bond, he'll need to go back on a scram monitor. And you just can't be drinking at all. But I think it's in the best interest of this individual to be transported to one of those two types of facilities, either an inpatient treatment facility or a sober living house, where I think he's got a reasonable expectation of making some progress between now and time of sentencing. I'll also order Mr. Likes as a condition of reinstatement of bond to fully cooperate with any pre-sentence assessments which are necessary. Mr. Likes, you might be asked to do another substance abuse assessment of some kind. You might be asked to do a risk needs assessment. You need to comply with those. Make sure those get scheduled with the court services department and those get completed prior to your February sentencing.
Drug test?
Well, it won't be testing necessarily. They may have to do another type of evaluation on you. All I'm saying is that if the court services officer wants you to do them, you got to do them.
Yes, sir.
Okay.
Where,
Yeah.
Mr. House,
Judge,
where was this inpatient place at? Inpatient?
Mr. Likes, I'll check with Road to Recovery, and that's the folks in Anothershe. And I'll also check with Mr. Florio. Might be a possibility that he could arrange transportation. We'll be working on that today.
To where?
To wherever we get you in the sober living house and when it's available, or in an inpatient treatment program if one's available immediately.
Court
Okay,
will condition his reinstatement of bond on good faith efforts to immediately enter either a sober living house or an inpatient treatment facility, as we've discussed here on the record. What I'm really worried about, Mr. Likes, is that I'm going to go ahead and let you back out on bond, and we're going to have another problem. We can't have another problem.
no, sir. No, sir.
Is your place in Howard in town or out in the county somewhere?
Out in the county.
Okay.
And I've got to move out of there. I was gonna be out of there by the 1st of December, and I didn't get around to that, obviously, because I was in jail.
Yeah. And without driving privileges, I don't want you trying to fudge the rules. So
No,
you need to live in a town where you can walk to get resources. Get to
Yep.
the store, whatever you need.
yes, sir.
Okay.
Which I don't have at this time.
Well, that's what one of these facilities could at least assist with in the short run. You'd have a place to go. All right.
Judge, with respect to the February 20th hearing, is that going to be by Zoom or is it going to be in person?
It's going to be by Zoom. Mr. Likes, I'm going to order you to participate by Zoom. I know without driving privileges, it may be a bit unrealistic to require you to appear in L County. You'll need to talk to Mr. House about how you're going to coordinate your Zoom appearance. I'm going to be a little bit more flexible than I normally am on this, Mr. Likes. As long as you're fully on the meeting with audio and video, you could do that from a treatment facility. You could do it from Mr. House's office. But again, I don't want you driving somewhere or having a transportation issue. So that I just want to make sure you appear for your sentencing by Zoom.
Yes, sir. I don't know.
You have a smartphone?
No, I do not. I can't. I don't. All this technology has passed me by.
Okay.
He usually has
I'm
someone bringing to-
illiterate.
All right. Now, Mr. Likes, if you end up by whatever reason in Eureka or El Dorado, it can be arranged that you could participate by Zoom in this case from one of those locations at the courthouse locations. Both the Greenwood County Sheriff's Office and the Butler County Sheriff's Offices has Zoom locations at the judicial centers. Okay.
Yes, sir.
So if you ended up in El Dorado, maybe you could walk over. We could make arrangements to have you participate from El Dorado or possibly from Eureka. I just don't know where you're going to end up here. Most treatment facilities are really good about using their laptops and equipment to allow their people to participate for court by Zoom. So if you're in a facility, I don't have much doubt that they're going to be able to set you up and allow you to fully participate. You'll need to make sure you stay in contact with Mr. House, and he can help you with whatever arrangements that you need. It's just that at February 20th at 9 o'clock, if you're out on bond, I need to make sure you're on that meeting.
Yes, sir.
Okay. And if you have any trouble with coordination in Zoom, make sure you get with Mr. House and he'll help in any way he can.
I have trouble with everything that's got to do with these machines that we're looking at.
So do I, Mr. Like, so I understand. But if you have any issue, you just need to make sure that you talk to Mr. House, and I'm sure he can make whatever arrangements are necessary to get you in front of a computer or a station. Obviously, you've always got the option of appearing at the Elk County Courthouse. The Elk County Sheriff's Office will accommodate you by Zoom if you show up there.
Yes, sir.
I don't know if that's realistic as to that's where you're going to be. Because I want you to get the the inpatient help or be in a sober living house if those beds are available. That seems to be the best possible scenario right now.
Mr. Florio works with Green Feather for Scram, so they can get that set back up.
Okay, Mr. Likes, you have any questions about what we've done here today?
No, sir.
All right, good luck. If you get out of the jail by making this bond, getting your bond reinstated and getting the Scram bracelet back on and going to one of these places, I just hope you're successful between now and court. It'll give you an opportunity to kind of show the court that you can be successful on a program. So good luck with that, Mr. Like.
Thank you, sir.
All right, Mr. House, is there anything further we need to address at this time?
I think you've covered it all, Your Honor. I will tell Mr. Likes, I'll try to call him up at the jail later this morning.
Okay. Mr. Likes, it also just occurred to me that you don't have a phone number
No,
that
sir, I don't have a phone.
we can give to court services.
I don't have a phone.
Judge, the jail has court services number 316-322-4153. They should have it.
Okay, could I ask the L County Sheriff's Office to allow Mr. Likes to call Court Services Department?
He's at Greenwood. This is his
Excuse me,
Green.
Greenwood.
Yeah, that's fine.
Okay. And then he can touch base with them and they can give him further direction as to what he needs to do regarding the pre-sentence investigation process. Because
Yeah.
once he gets out, then there may be a breach in communication abilities. So if he can just at least touch base with court services before he leaves your facility, I think that'll be a step in the right direction.
Okay.
So thank you. I do appreciate your office's cooperation with this case. All right. If there's nothing further, then the George Allen Likes matters will currently be in recess, and this meeting may be ended for all at this time.
Thank you, Judge.